Hello friends and welcome to Study IQ. I am Joycey Joy and today we will be discussing about the detention of elected representatives in Jammu and Kashmir, and in this background we will analyze Article 22 which deals with preventive detention in India. Also we will see what is the current situation in Jammu and Kashmir. Also we will discuss about the reaction of the parliament about the detention of the elected representatives in Jammu and Kashmir. We will also discuss what is the way ahead. So preventive detention is a very important topic from your UPSC perspective, and since this is in the current affair in the news recently and very frequently, it is very important. So let us first come to the current affair. Let us see what is the current affair that is related to preventive detention in India. So more than 1,300 people, including many elected representatives, were detained around the centre's abrupt move that bifurcated the Jammu and Kashmir. We know that Article 370, which gave a special status to Jammu and Kashmir, was repealed by the Parliament. Also, the state of Jammu and Kashmir was bifurcated into two union territories, and around this abrupt move by the central government, many people were detained. That is, preventive detention was charged against many people in Jammu and Kashmir, and the detainment is still continuing even after 15 weeks of this incident. So even after that, this detention for some of them, it is still continuing. So in this context, we will be looking at preventive detention law in India. So we will be moving on to the current situation in Jammu and Kashmir. But before that, let us briefly discuss about Article 22 of Indian Constitution and various provisions of this article. Before that, first we will discuss about the preventive detention. So what is meant by preventive detention? You know that a person can be put in jail or taken under custody for two reasons. One reason is that if the person has committed the crime. So for the commitment of a crime, a person can be taken into a jail or taken into custody by the police or by the magistrate. And second reason is that if there is a potential to commit a crime in the future, then also a person can be arrested or taken into custody. So this is where the actual crime has not happened, but there is a possibility or potential for the crime to be committed. So the custody that is arising out of the potential for a crime in the future, here the person is only likely to commit a crime. So this situation is called preventive detention. The first situation, it is punitive detention, whereas it is second one, it is preventive detention. So the definition of preventive detention itself is very confusing. For example, how can you say that a person will commit a crime in the future? Also, the implications of arresting a person without having committed a crime, etc. So this is very confusing. Now let us come to Article 22 of Indian Constitution, which is a fundamental right. Now Article 22, it makes the minimum procedural requirements which must be included in any law enacted by the legislature in accordance with of which a person is deprived of his personal liberty. That is why Article 22, Clause 1 and 2. This is called rights of an arrested person. So a person, if arrested, the person has got certain rights, and it is discussed under Article 22, 1 and 2 of the Indian Constitution. Now let us come to the rights of the arrested person. Let us see what are the rights. First one, a person cannot be arrested and detained without being informed why he or she is arrested. So the reason of arrest must be clearly indicated to the person who is arrested or taken into judicial custody. Now, second one, a person who is arrested cannot be denied the right to be defended by a legal practitioner of his or her choice. So here the person who is arrested has the right to be defended by a lawyer or a legal practitioner. This means that the arrested person has the right to hire a legal practitioner to defend himself or herself. Now the third right is that every person who has been arrested would be produced before the nearest magistrate within 24 hours of the arrest. So within 24 hours, he or she must be produced to the nearest magistrate. Now, next one is that the custody of the detained person cannot be beyond the said period by the magistrate. So the magistrate would be giving a period of custody. So the detention or the detained person cannot be taken into custody even after the period that is agreed upon by the magistrate. So these are the rights of an arrested person. Very, very important. Now, Article 22 clause 1 and clause 2 make the above provisions. Now, coming to Article 22 clause 3. So, Article 22 clause 3, this is an exemption for the above rights. So, under Article 22 clause 3, this says that the above safeguards are not available in certain situations. Now, first one is that if the person who is arrested is an enemy alien. So, if he is an enemy alien, these rights are not available. Now, second one is that if the person is arrested under the law of preventive detention. So, if an arrest is made according to the provisions of preventive detention, then also the rights of the arrested person will not be available to this person. So, this is Article 22 clause 1, 2 and 3, very, very important with regard to preventive detention. So, I hope you have an understanding about preventive detention now. Now, let us move on to the current situation in Jammu and Kashmir. So, the current situation in Jammu and Kashmir, many detention continues. That is, the detention in accordance with the bifurcation of Jammu and Kashmir and the repeal of Article 370, many of the detention still continues, and this includes elected representatives as well. So, representatives who were elected by the government are also included under the list. Now, here, what is to be noted is that the senior functionaries of the government have repeatedly said that the situation in Jammu and Kashmir is normal. So, the government claims that the situation is very normal, but still the detention is continuing. But the indefinite preventive detention of people, it is very difficult to justify under any circumstances, and especially when the government itself claims that the situation in Jammu and Kashmir has come back to normal. Now, what are the other issues related to this? There are restrictions again on communication, on movement of the people, etc. So, this clearly indicates that the situation in Jammu and Kashmir has not come back to normal. But again, there are certain signs of normalcy. For example, more businesses are open, more vehicular traffic in the valley. These are all indications of normalcy of situations or things have become normal. So, when there are signs of normalcy in the state or in the union territory, the present union territories, the government cannot see any merit in undermining the mainstream political leaders in Jammu and Kashmir. Now, let us come to the reaction in Parliament. So, in the Parliament, Prime Minister Modi spoke about the Constitution Day recently, and also he spoke about the role of Rajya Sabha in sustaining the federal structure of India. So we know that India is a federal country where we have the union government, also we have the state government, and the third tier we have the local governments. So we have a federal structure. So he also highlighted the role of Rajya Sabha. Rajya Sabha is the upper house of the parliament, and the Rajya Sabha plays a very important, vital role in sustaining the federal nature of the country. So he spoke about all this in the winter session of the parliament. But the paradox here is that there is no commitment from the government in removing the detentions and the restrictions in the state of Jammu and Kashmir. Now, the role of parliament. The parliament is a group of members who are elected by the people, the representatives who are elected by the people. So, parliament is for giving meaningful voice to the people. So, what does it mean? It means that when the elected representatives are detained, this is preventing these representatives from attending the house, and they are also denied the right to speak for their people whom they are elected to represent. And also, the non-deliberative manner in which the full-fledged state of Jammu and Kashmir, which was reduced into 2 union territories at one go or one stroke, was an unprecedented assault on the federalism, on the federal nature of the Indian constitution. And also the disruption by the opposition is a marginal challenge to the role of parliament at present. And two very important challenges for the parliamentary democracy in India at present. One is the undermining parliamentary committees. What is the role of parliamentary committees? The role of parliamentary committees is to scrutinize the decisions of the government or the actions of the government. So undermining the parliamentary committees, taking away the powers of the parliamentary committees will not lead to effective scrutinization of the government actions. So undermining parliamentary committees. Second one, labeling any bill as money bill. Why money bill? What is the speciality? Money bill has to be passed only by the Lok Sabha, and Rajya Sabha has lesser role in money bill or passing of the money bill. So these are the two very important challenges at present the constitution or the parliamentary democracy in India is facing. Now, what is the way ahead? What has to be done? On the 31st of October 2019, the two union territories, they came into being, and also the governors, the lieutenant governors have taken charge. So, since the lieutenant governors have taken charge of the union territories, immediate steps can be taken in order to open up political and civil society space in Jammu and Kashmir, in the two union territories, the bifurcated two union territories. Now, second one, instead of trying to hard sell an improbable portrait to the outside world, that is the government is claiming that things are very normal, the government, what it should do is to engage with those most affected by the decisions, that is the people of Jammu and Kashmir. They are the people who are the most affected. So instead of telling that the situations are normal, government should actually engage with the people of Jammu and Kashmir, try to analyze and study their issues and come up with solutions for their issues. Now, in this context, it is also important from the UPSC perspective to learn about the Jammu and Kashmir Public Safety Act. Very, very important. So, we will briefly discuss about this also in this lecture. Now, why it is important? Because security challenges, management in border areas, all these are important for your civil service examination, especially in your mains examination under paper 1. So, from this perspective, it is important, and for your preliminary examination, key features of the Act can be important. Now, this has been in the news very frequently. This can be a potential question. Now, let us see what is Jammu and Kashmir Public Safety Act, the PSA. So, Jammu and Kashmir Public Safety Act received the assent of the Governor on 8th of April 1978. Now, the Act was introduced as a tough law to prevent the smuggling of timber and keep the smugglers out of circulation. So, the very purpose of bringing the Act was to prevent the smuggling of timber from the state. And what does it mean? This Act, this law, allows the government to detain any person above the age of 16 years without trial for a period of 2 years. So, any person can be detained by the government without trial for up to 2 years, and also it allows for administrative detention of up to 2 years. And the detention orders under the PSA Public Safety Act, it can be issued by divisional commissioners or district magistrate DM. And section 22 of the Act, very, very important, section 22 of the Act, it provides protection for any action taken in good faith under the Act. So, if any action is taken under good faith under the Act, it provides for protection. And under section 23 of the Act, the government is empowered to make such rules consistent with the provisions of this Act as may be necessary for carrying out the objects of this Act. So, section 23 is also important because it empowers the government to make any rules in order to carry out the objectives of the Act. So, these are the important provisions of the Public Safety Act. Now, why this is called a draconian law? This is because right from the beginning, this law was highly misused. So, this was misused widely, and also in the year 2018, this was amended to allow individuals to be detained under the PSA outside the state as well. So, this was extended to outside the state also in 2018. Now, third thing is that the detaining authority need not disclose any facts about the detention. That means without stating the reason, a person can be detained. Another reason is that PSA Public Safety Act does not provide for a judicial review of the detention. So there is no scope for judicial review of the detention. So this ensures that the detention of the people can be for a prolonged period. So these are all some of the features that makes this act a draconian law. So this is also important from your UPSC perspective. So when we talk about the preventive detention in Jammu and Kashmir, this is also a very important topic. Now you can find the PDF of this lecture on our website www.studyiq.com. You can follow my Facebook page for more video updates. You can write to me at joycey.studyiq@gmail.com for any of your queries and clarification. Thank you.